Everyone, I am Advocate Sokoni, and today we are going to deal with the Constitution of South Africa. So it is a subject in constitutional law, which is done by second level students at the University of Zululand. I just want to do this lesson in order for you guys to have a basic understanding as to what the Constitution stands for, how it came about. I'm not going to dwell much on the history of South African politics because we all know we are coming from a situation where South Africa was colonized, and after that there were the people who came from Europe and took over the whole of Africa as mandated by what was called the Berlin Conference in 1884, which told Europeans to come to Africa and divide Africa for their benefit. Some call it they wanted to loot the resources, some call it they wanted to subjugate the kings and chiefs in Africa. Okay, that is not our topic so far. Our topic is about understanding constitutional law in the South African context. Right, I'll just simplify so that you will understand. And the best way to understand the Constitution is to do your research, do your reading around the Constitution and the cases that I may give you, which deal with constitutional matters. Right, there was a case of State versus Bosak. That was a 2001 case. It's 1 SA 912 CC, and you read paragraph 12 where it tells you about jurisdiction. It's all about jurisdiction, but we'll come to that. Right, let us go back to defining the Constitution. What do we mean by what is a constitution? We need to know that, and we also need to know what is democracy, right? And there are so many definitions that you might find regarding the Constitution, but to simplify it, it will be the agreed rules that a country will be ruled under. That is the Constitution. So you will have articles. For instance, we had the 33 constitutional principles that formed the foundation of our Constitution. So now, where did all these principles come from? Somewhat in 1993, the National Assembly, must remember now, 1993, in 1993, the president was F.W. de Klerk, which means South Africa was still governed under the old apartheid rule. But there was an act which was promulgated in 1993, and it's Act 200 of 1993. And what is it? It is the Interim Constitution Act, which contained all those principles that were the foundation for the present Constitution. So that is where we need to start. Okay, and so we've had the Interim Constitution of 1993, that is Act 200, from where all these this constitution that we have, which is called the New Text, it's called the New Text, was formulated. Okay, So today we have something called the Constitution of the Republic of South Africa, which is Act 108, 1996, which is also described as the supreme law of the Republic, right? And it also states that law or conduct which is inconsistent with it will be deemed as invalid. That is very important. And there will be obligations imposed by the Constitution, right? And those obligations must be fulfilled at all costs. Anything that goes beyond or off the rails or is not in conformity with the Constitution will be regarded as invalid. So all the laws in South Africa should comply with the Constitution. Okay. But I know that you are of the impression that for a Constitution to be amended, you will only need a 2/3 majority, which is correct. For a Constitution to be amended, you need a 2/3 majority. But the mistake that most students do is to think that the Constitution can only be amended if the ANC, as the ruling party, gets a 2/3 majority of voters. It gets voters that will make it have a 2/3 majority. That is a wrong perception. We know that in Parliament we have 400 members, right? And for any party to have the majority, it must have 200 plus 1, right? So that it can be able to make laws without being opposed by the opposition, right? But for an amendment of the Constitution, you need the 2/3 majority of the members, of the elected members of the National Parliament, whether in the opposition or the ruling party. That is point number one that everyone who studies constitutional law should understand. So, to date, which could be even more than that, I know I am going to talk about 17 amendments that have been made in our Constitution from 1994, 1994 to date. We have had 17, not less than 17 amendments. Then, we will then talk about that as to how did it come about. Okay. First of all, before we go to Constitution, we need to know about the type of governments, right? There is something, or types of constitution, let me say, because even in a monarchy, there is a constitution, right? Even in an oligarchy, there will be constitution. Even in a aristocracy, there will be constitution. Also in a democracy, there will be a constitution, right? We've heard of something called the constitutional monarch of Lesotho, of Swaziland, and also the UK is also a constitutional monarch. It just differs because the degree of control of the monarch is different, especially in the UK. It's not absolute, but as compared to countries like Lesotho and Swaziland, where the monarch is actually the driver of what is going on in Swaziland and in Lesotho. Okay, now we need to define the meaning of the concept constitutionalism or constitutionality. You need to be able to define that meaning in order for you to understand exactly what is meant by these terms. Okay. Right, let me stop there for now, and then we will deal with each chapter, because I don't want to take more than 10 minutes, because students normally says they are bored with me talking forever. So I will end with this 10 minutes talk and start all over and continue from there.